you mentioned Compass Pathways, this I think London-based startup, right, who are big international players now. I think one of the groups that got breakthrough status by the FDA in America, right, to roll out psilocybin. And you mentioned that, so they've not, whilst they've successfully received a patent for psilocybin, it doesn't mean that, if you're someone in Amsterdam where it's legal to consume psilocybin containing truffles, this doesn't affect you, right? Because that's just natural psilocybin. But what they've patented is a lab-based method of synthesizing psilocybin, right, from chemicals. And so that's a claim that's how the kind of novelty, I guess someone could argue, right, that is patentable.
Yes. So, and that is one of the things that they've patented. So actually in the UK, they have a patent on the process. So the method of manufacturing their synthetic psilocybin. In the US, they have that pending, but it's not been granted yet. But they also have 3 patents that cover this polymorph, which is like a crystalline form of psilocybin. So it's like their sort of GMP formulation. It's like a 95% or more pure formulation of a polymorph. So the polymorph is just like the way that the psilocybin molecules, when they're collected together, like, millions or billions of them pack in like a crystal form. So there's a variety of ways that can happen, and they've patented like one specific way of packing them together. So I think there has been concern whether that way of packing them together would be like the only real way to get GMP psilocybin manufactured, which then would be potentially possible for them to use that to exclude others from getting like FDA approval, because nobody's going to be able to get FDA approval of a psilocybin mushroom. But it does mean that they only have protection very narrowly for that specific polymorph of psilocybin. So that that particular 3D packing structure of the psilocybin molecule in a pure form with particular excipients. So of course, somebody taking psilocybin mushrooms or somebody taking truffles in Amsterdam doesn't have to worry about infringing Compass's claims.
And when it comes to, there have been lots of question marks over the kind of ethical conduct, I think, of how these patents have been sought. And I think one of the main ones was that this compound, I think they call it Comp 360, this particular form of psilocybin, or the method for producing it is effectively the same as Albert Hofmann's method, the first person to synthesize psilocybin. And so there's been arguments that it doesn't actually represent a kind of, they are not the people who should get the credit for this method. It's not a genuinely new step forward.
Yeah. So that was a big debate that took place, and their patent, after it issued, was challenged on that basis. And that evidence was put before an administrative board, who actually decided not even to take up the case, basically finding that evidence wasn't sufficient to show that there was, in fact, this doubt that they had claimed the Hofmann method. But I think, there's certainly some ways to argue that procedure, perhaps, both may not have had the, a sufficient amount of evidence to prove that what Hofmann did was in fact the same as what Compass is doing, because techniques change and the sort of ability to do analysis of a compound changes. So that may be the case that there was in the prior art this particular polymorph, but that was a challenge that was made to their patent. But it also goes to show, there's been some dispute too, it's not so bad if people end up getting these really broad claims, because others can just go to the patent office or just challenge them later after they are issued. And I think this is probably a good example of how that's, it's difficult and it's expensive. And, I don't know the bill for that, but it was probably, in the 6 figures, certainly. And for people that get sued by somebody with a patent, even if that patent is, ultimately going to be found invalid because it was claiming something in the prior art and it was a novel, taking something in district court litigation to try to show that it's invalid, that can now be, hundreds of thousands, millions of dollars even. So it's, it's a pretty high sort of barrier. That means that it is really important for the patent office to grant patents that are, not overly broad and not claiming into the prior art, because that's really the chance to make sure that those don't get granted, because there aren't going to be a lot of people with the resources to challenge those later. And, it creates a asymmetry between the patent owners and people who are threatened by the patent. And it's the psychedelic space is still pretty young, and I don't know what Compass's intent is and how they want to use these, but in other spaces, in the software space or tech spaces, we've had all these patent trolls who kind of make it their business model, really. And there's even ones on the public market who have made it their business model and taken public investment to basically buy up patents and sue others, knowing that there's this asymmetry in the fact that they can usually extract some sort of settlement, because folks just don't want to pay even $100,000 at the very outset to just kind of investigate and defend a case. So the possibility of there being sort of predatory actors, patent trolls, who could get their hands on psychedelics related patents and potentially cause damage in the ecosystem is something that should mean that people now, while these patents are still pending, should kind of pay attention and try to ensure that overly broad patents don't get issued to whomever, even if they're getting issued to people who we think are good actors with their best intentions. They can always end up in the hands of others ultimately. So it's it is a important kind of thing I think to pay attention to.
Yeah, and on the topic of these being kind of non-obvious, that in order for something to be granted, it needs to be non-obvious and novel. As a scientist, I'm who works in the kind of academic space that isn't for profit. It's a lot of these things, it's very clear that you're standing on the shoulders of giants, and there's a lineage of research that goes back decades, and not to mention the indigenous use. But with something like psilocybin, we have kind of the Hopkins research and then Imperial, and then the idea that one should roll this out, synthesize psilocybin and use it for mental health issues is not it's already there in the academic literature. It's not like, as you were saying in the beginning, that these patents can often serve as a kind of incentivizing new discovery, right? It seems kind of an obvious thing that needs to be done, and to kind of, I guess there's a bit of a land grab going on, right? Where there's situations like that, where there's money to be made, people can kind of just try their best to claim that they should be the one to profit from it, even if there's not really any significant novelty to the method that they're particularly proposing.
Yeah, I mean, I think that's definitely true. And that's, a failing that's not just something that exists in the psychedelic space. I mean, that's been a criticism of the patent system, for almost time immemorial, at least as far as the US patent system goes. There's Supreme Court cases dating back to the, 1800s, early 1800s, talking about this. So this has been something that, the courts have tried to grapple with, and there's been a lot of reform efforts in the patent laws, but it's something, because the value of a patent is so great, people will always try to find ways to obtain patents, because you can think of it just almost in some extent like kind of a lottery ticket. Like you file enough patents, you can often get some claims granted, and the value of those claims can tend to be greater than the amount of money that you paid to file those patents. So sometimes it's a strategy that people will take just to see how many patents they can sort of get issued in a particular space. And they, the bigger game in any space is because other people are doing the same thing. Why would you sort of miss out on it? So oftentimes, I mean, a land grab is not a bad analogy, because it's kind of an open space. People know that there aren't claims yet filed and granted, so people will sort of try to take them for themselves, because if they don't, somebody else potentially will. But yeah, it's certainly there is something that's, I think, I couldn't tell you how many articles I've read that have been titled it, but it's like patenting inventions or inventing patents. But it's like, yeah, I mean, a lot of times people are trying to come up with ways to obtain patents more so than they're using patents to like protect an invention that they've already come up with. So you can see that as a failing in the patent system, but it's not really a failing in the psychedelic space so much. It's just obviously it clashes more, I think, or is in tension with the sort of ethos that people in the psychedelic space may be maybe presenting, or that may have.
Right. And I think that that point about how some groups will file lots of patents and basically just see which ones stick is really interesting because, I think it's important to say that when you see the headlines around these things, I think people can often miss whether the patent has been granted or just filed. Sometimes companies will successfully get a patent, or sometimes they'll be filing for something, they won't get it, but it's just an attempt. And I think one case was Compass again, who had attempted to patent basic pretty much standard aspects of psychedelic psychotherapy, like holding hands with a therapist and soft furnishings. I think, am I right that that wasn't actually
That's right.
granted?
Yeah.
And that was just filed.
Right. Yeah. So that's only just been published in October, and they actually have another year from the date of publishing before it would even enter prosecution in any countries. So it was filed as what's called like a patent cooperation treaty or PCT application. These basically just allow somebody to file a single application at a single office. It's like part of the United Nations, actually called WIPO. And then they have 30 months from the date it was first filed before they have to enter national prosecution in different countries. So starting in October next year, we may see it be filed in different countries around the world like some of their other ones have. And then even from that date, it's going to be a year and a half, 2 years maybe before it even sees an examiner, unless they can pay or otherwise try to like accelerate the examination. But it may be 3-4 years even yet before there are any issued claims from that. So yeah, that's just a a filed application, and the claims often in a filed application will be as broad as anyone thinks it can possibly get. I mean, it's really sort of staking out the furthest sort of boundaries of the territory you think you may potentially get. So some of the outcry, I think, it's definitely warranted because it still shows that they have a strategy for this. But like ultimately, I think it's unlikely that they would get those sorts of claims. But it's I don't know their intentions, and I wouldn't ascribe any to them. But it does indicate, I think, that they are certainly considering trying to get broad claims or as broad claims as they can to cover psilocybin therapy.
Right. So yeah, I mean, I guess that's the concern, right, of monopolization, that they would attempt to kind of limit access by only having them be the people who could provide this.
Yeah, I think so. And there's another aspect sometimes too of filing these broad claims is even if you think you may not get it, it also sort of dissuades others from entering a particular space because it does create kind of a risk to people because they don't know if these claims will be granted or not. And they know now you have the earlier date. So, it can potentially dissuade others from sort of entering that space to compete with them. But I think also, one of the things that was notable about this patent that was different from their granted ones in the US around this polymorph is that with this PCT application, I mean, they covered the use of psilocybin in therapy, just psilocybin. So, if these claims were granted as they stand, that would mean that even under like Measure 109 in Oregon, which allows for psilocybin therapy with just natural mushrooms or psilocybin extract, in theory, if these claims were granted as is, they would also cover like that if it was in a room with soft furniture and with these other things. So I think that's part of why those were seen as being so problematic.
Right. Yeah, I mean, we'll have to wait and see, but I not knowing anything about this space, I would be shocked if that was granted that, in a way that prevented, but just based on intuition, I know nothing about this legally, but if it was granted and say you're a psilocybin therapist in Oregon where it's legal and you're using fresh mushrooms, would the risk be that you could be sued by the company for using their technique of interacting with the therapist?
That would be the risk, certainly, and I'd be like one step below shocked. I mean, I've seen certainly a lot of patents be granted with claims that are fairly outrageously obvious. Hopefully, I think in this circumstance, it's not going to go through unnoticed. So, if it looks like it's approaching a grant with claims that broadly, I feel like there's going to be an attempt like there was with the polymorph patent for people to file some kind of objection to it, which would probably be enough attention for the examiner not to let it through. But yeah, I mean, I would be pretty surprised, I would say. But yes, I mean, if it was granted, that would potentially give Compass the ability to sue anybody who is practicing what's covered by those claims. I mean, so the claims of a patent basically draw your property lines, and anything that falls within them, you have the right to exclude everybody from doing. So if they had a claim that was just using psilocybin in therapy under, these sorts of limitations, like that are in that claim or those claims, I mean, that would keep anybody else from being able to do that at risk of being sued for infringement. So, in practice, it's unlikely that Compass is, I would think, going to sue individual therapists. They may sue the sort of therapy centers, or bigger competitors who are trying to open therapy centers in Oregon. But there's certainly been examples like again, patent trolls suing everybody who does something, even little mom and pop shops and stuff, just either trying to get them to stop or trying to get a small settlement amount. But it's obviously it's a reputational kind of risk to consider too. Although I don't know how much they're or how well they are looking after their reputation in this way. So potentially it's something they would pursue. But yeah, it would be surprising to me to see claims of this sort granted.